Hello, welcome to this presentation on how the criminal justice system in England and Wales is organised. We're looking at the roles of the specific agencies within that organisation, and this PowerPoint is going to concentrate on the courts and the judiciary. So without further ado, let's get into it. So, His Majesty's Courts and Tribunal Service is responsible for the administration of criminal, civil and family courts and tribunals in England and Wales. In general, in this course, we're just looking at the criminal courts, but be aware there are other courts as well. We've got a civil court system and a criminal court system, and as I said, we are concentrating on this one. But you need to be aware that the other ones exist. So civil courts deal with civil disputes, private disputes between people, businesses, things like damage claims, court injunctions, divorce, land issues, those sort of things. Whereas criminal cases are dealing with those who've actually committed a criminal offence, such as theft or armed robbery, etc. And the reality is, in a criminal court, if you're found guilty, you're going to get punished. Simple as. So, in the criminal court system, we have two criminal courts of the first instance. And first instance means where your case is going to be tried first. So all criminal cases will start in a magistrate's court, but they may not be heard in a magistrate's court, but they all start off in a magistrate's court. And then they'll either be heard in a magistrate's court or they'll be heard in a Crown Court. So where your case is heard in the first instance is the magistrate's court or the Crown Court. We've got three categories of criminal offence. All of this stuff you absolutely have to know, guys, so make sure you're clear on it. We've got summary offences. Now, summary offences are our least serious offences, things like speeding, assault, and they are tried in a magistrate's court. So magistrates' courts try summary offences. Summary offences are the kind of offences the police are allowed to charge on their own without asking for the CPS's permission. We have triable either way offences. Now these are more mid-level, such as ABH and theft, and they can go to either a magistrate's or a Crown Court, depending on how the defendant pleads and or the sentence that would need to be imposed. So, for instance, in a magistrate's court, and we're about to find out, the maximum sentence they can give for only one crime is 6 months. So it may be that you have a criminal who is charged with an offence that carries a maximum sentence of 12 months. So in theory, now let's do this right. A maximum sentence of 8 months. So in theory, it couldn't be heard in a magistrate's court. But if you plead guilty at the first chance, you get a third knocked off your sentence. So that would reduce it to below 6 months. So therefore, it could be heard in a magistrate's court. So that's what we mean by triable either way offence. Depends on the plea, depends on the maximum sentence, that sort of stuff. Okay? And then finally, we have indictable offences. Most serious offences, murder, rape, etc., they have to be tried in a Crown Court because the minimum sentence is going to be more than 6 months. So all cases start in a magistrate's court, and then the magistrates decide whether they can hear the case in a magistrate's court, in which case they'll set a date in the magistrate's court. They decide whether it's an indictable offence or a triable either way offence that needs to go to the Crown Court, and in which case they'll set a date in the Crown Court for that. So everything starts in the magistrate's court, but the first instances of actually hearing the case are in either the magistrates or the Crown Court, depending whether it's summary, indictable, or triable either way, in which case it could go to either court. I hope that makes sense. The Magistrates' Court also has a youth division which deals with the cases of people who are accused between the age of 10 and 18, just for info. So there is Plymouth Magistrates' Court. All cases, as I said, start off in the Magistrates' Court. They then make the decision as to whether the crime is summary, triable each way, or indictable. So pretty straightforward. Worth mentioning though that there are other courts in the land, and we have had a question in the past: name 3 courts in England and Wales. So this is where we get into the Courts of Appeal and the High Court. So here's your Magistrates Court. Okay. Now, if everything starts in a Magistrates Court, so summary offences are heard here, but the Magistrates Court, if it's a triable either way offence or indictable offence, they refer the case up to the Crown Court. So those are the 2 courts we've looked at. If someone's been found guilty in a Magistrates Court and they don't agree with a sentence and they wish to appeal, and that might be the defendant, or it might be the Crown Prosecution Service who feel that the sentence has been too lenient, they can appeal to the High Court, where 3 judges preside, and they hear appeals from magistrates' courts on points of law. If they're still not happy with the result of the High Court decision, they can appeal further and go up to the Supreme Court, which is the highest court of the land. So an appeal from Magistrate Court goes to the High Court, and if it's not dealt with there, goes up to the Supreme Court, and that is the final decision. If, however, a case is heard in a Crown Court and you wish to appeal, that then goes to what is called the Court of Appeal. And if you still don't agree with that, you can go 1 step higher, back to the Supreme Court. So basically, we've got 5 courts in the land: Magistrates, Crown, High Court, Court of Appeal, Supreme Court. All of those are fine. Okay, let's move on. So let's delve a little bit deeper into the workings of the Magistrates Court. So magistrates are what are called lay people, and this is a technical term sometimes used in questions, so make sure you understand what the term lay means. So lay people are basically amateurs. They are non-professionals. So magistrates are not legally qualified. They sit as a magistrate on a voluntary basis for a minimum of 26 half days a year. Sometimes magistrates are also referred to as justices of the peace. They're a key part of the criminal system because 95% of cases are completed in the Magistrates Court. And they also deal with a lot of civil cases, antisocial behaviour, public health, all that sort of stuff as well. So that's good, because these people are volunteers, they don't get paid, so it's cheap. Where cases require a penalty greater than the magistrate's sentencing powers, they get sent up to the Crown Court, as we've already discussed. So magistrates can only sentence up to 6 months imprisonment and a maximum of 12 for 2 or more offences. Now, the textbooks are wrong, because the law has changed since the textbooks were written. The textbooks, it's nothing it says they give a maximum fine of 5,000 or 10,000, I can't remember what it is. But actually now there is no limit on the fines that magistrates can impose. So that has changed. The law has moved on. Laws change over time, as we know from this course. So do not go with what the textbook says. It is incorrect. So there's my definition: layperson, an amateur, someone who's not trained, qualified, or experienced in a particular subject or activity. So here's basically how a magistrate's court is set out. If you want to see a video of it, that's the link that you need to go with. But here's my little explanation. So we've got, starting at the top, 3 magistrates. 3 magistrates, hence the word tribunal, because there's 3 from the Latin tri. They're all lay people, they're amateurs. They listen to the case, decide whether the defendant is guilty or innocent, and they sentence the defendant if they are found guilty. So the magistrates decide on the guilt and decide on the sentence. In front of the magistrates, you will have the court clerk. Now, the court clerk is the professional legal expert in a magistrate's court. They are the person who's ensuring the case is conducted fairly, and they are the professional that advises the magistrates on points of law so they don't make mistakes. You'll then have the prosecuting advocate who works for the CPS, a professional solicitor who brings the case against the defendant. And against him, you'll have the defence advocate who will be employed by the defendant, a professional solicitor who defends the accused. We also have then the usher, another lay person, and the usher is employed by the court to escort witnesses in and out of the court, that sort of thing. Smooth running of getting people in and out. And then we quite often will have a probation officer in the court. They often attend to give a report on the defendant prior to sentencing if they've been found guilty, and that will inform the magistrates as to whether they should give a custodial sentence or whether a community sentence would be better. So, worth thinking about. And what I'd also say to you, you're all studying criminology, notice at the back of the magistrates' court, and you'll notice the same when we get onto the Crown Court, there's a public seating area. You have the right to go into a magistrates' court and sit at the back of a magistrates' court and indeed a Crown Court to watch any case you want. You do not have to pay, it's free of charge. You have to go through security and empty your pockets, etc. But you know, if you're into criminology and you're thinking about taking it up as a career, I would spend, you know, you've got your summer holidays coming up or a free day, get yourself down to the local magistrates court, sit at the back, see how things work. And likewise, you know, you can do exactly the same in the Crown Court. You can get a nice juicy murder case. Who knows? So go and do that. And also, when you're applying for uni, the fact that if you want to study criminology, the fact that you've done that shows that you've got a bit extra compared to other candidates. So have a think about that. Anyway, let's move on to the Crown Court. Very similar. Now, the only real difference is we've got a jury made up of lay people. There they are. Anyone over the age of 18 can be called up for jury service, and it's the jury who listens to the evidence, and it's the jury that decides the guilt or innocence of the defendant. So in our court system, your guilt is always decided by your peers, your equals, lay people. In a magistrate's court, it's the 3 magistrates who are lay people. In a Crown Court, it's the 12 jurors who are lay people. Now, interestingly, in a magistrate's court, you have 3 magistrates, so you don't get a split decision. That's part of the reason why it's a tribunal. But in a Crown Court, you have 12, so you can get a split decision of 6 versus 6. And the only reason we have 12 people in a Crown Court is because Jesus had 12 disciples, and it's from our religious heritage. So if we're talking about going back to Unit 2, how culture plays an influence, well, there you go. 12 jurors because 12 disciples for Jesus. So the jury are the lay people, and then the judge is the person who manages the trial, ensures fairness, gives the summing up, and it's the judge that passes the sentence in this case. So other than that, it's virtually the same: prosecution, ushers, defendants, press, etc., etc. But note the public gallery, you are entitled to go and watch a Crown Court case. It doesn't cost you anything. So let's delve a little bit deeper into this use of lay people in the court system. Sometimes get a question on whether it's a good thing or a bad thing. So let's have a think about this. So, good points about magistrates. They're volunteers, so they don't cost us money, which is a good thing considering 95% of cases are heard by magistrates. If we were to, this is a good stat to have this one, if we were to replace them with district judges, which is the lowest paid rank of judges, the cost would be £100 million a year. That's a vast amount of money. So a huge saving is made by having magistrates. We talked about appeals to the magistrates. You know, you would appeal if you think they haven't done a good job. In reality, there are very few appeals from magistrates' courts. So that would suggest that actually they perform well. Magistrates are local, They have local knowledge of the problems facing defendants, so you could argue, excuse me, that they're better pressed to, better cited to deliver justice in the local area. And also, despite the fact they're lay people, they do receive training, and they've also got that legally qualified clerk to help them. So it is quite rigorous, the training that they have to go through. However, oh, and of course, cases are dealt with quickly. Forgot about that one. Cases are dealt with quickly. In a magistrate's court, usually they're done in a couple of hours, if that, as you'll see if you get out to a magistrate's court. But there are some downsides to this. So, quite often, the social background of the majority of magistrates isn't a true cross-section of society. Magistrates tend to be predominantly middle class and middle to old aged. Now, that is because if you've got to spend all those half days every year turning up to court, if you're in a full-time job, your employer's not very likely to let you have all that time off paid. So a lot of people can't afford to do it unpaid. So it suits people who are either retired or who have less work commitments, which tends to be older people, and also, not that in any way that I'm being sexist, but the reality in our society is that it's often stay-at-home mothers, that sort of stuff. So it's quite a big female demographic in magistrates as well. Okay, I mean, I tried to retire from teaching, failed miserably. At one stage I thought, what shall I do if I don't teach anymore? And I actually considered applying to be a magistrate to use some time, but I'm in my 60s now, so I know you look at me and think, how can that possibly be true? So again, I would fit into that middle class old demographic if I chose to do that. Magistrates are often criticised for being out of touch, therefore, with the majority of defendants, which would be a weakness. And at the same time, because they hear a lot of cases, some people, I'm not sure if this is a good criticism or not, say that they become case hardened, they become unsympathetic to the people in front of them. And there is some evidence of inconsistency in sentencing amongst magistrates. So if you're, I don't know, sentenced in Newcastle, sentenced in Plymouth for the same offence, sentences can vary, where, as we know, there should be parity across all sentences. So you do get a bit of a geographical lottery, albeit that the maximum sentence they can give is 6 months. So that's an issue. If we move on to lay people in the court system, here we're now talking about juries. Now, lay involvement ensures public confidence in the justice system because it's the people that are deciding the guilt, and I think that can only be a good thing. It's not the government, it's not the police, it's the people. And jury selection is completely random, so it ensures a complete cross-section of society, so that promotes neutrality. So as soon as you hit 18, you can be called up for jury service. Now, I've gone through 60 years on this planet and I've never been called up for jury service, and yet I had a sick form many years ago. I had to write a letter excusing an 18-year-old girl in my sick form from doing jury service because she had her A-levels to do when she'd been called up. So it can happen at any time, folks, and you can discuss with your teachers whether you're allowed to get out of it or not. The reality is you're not. You've got to have one good reason, and they might let you off for one good reason, but you won't get away with it a second time if you're caught. And because they're independent, they can never be pressured to return a guilty verdict. And you'll have done some case studies like Kay Gilderdale, etc., where the defendant's been clearly guilty, but in the eyes of the law, in the eyes of the jury, they were deemed to be innocent because they were sympathetic. And juries make their decisions in private, and therefore they shouldn't, in theory, be pressurised by outside influences. So those are some strengths for using lay people in the Crown Court system. However, there are also weaknesses. So because you pull from all parts of society, you are occasionally going to get the odd, less intelligent person on a jury who may not have the intelligence or ability to understand the evidence. And so for some jurors, that can often lead to slow, expensive trials, as jurors have to have points of law explained to them. And increasingly, jurors are conducting research into the case using the internet, social media, and they're not allowed to do that, but they do. And that sort of, well, it's not sort of, it does, gets rid of that idea of neutrality. And in general, acquittal rates are much higher in a Crown Court than a Magistrates' Court. And that, some people have suggested, is due to the irrational verdicts that juries give, which makes justice haphazard. And this little article here, if you want to go and look at it, I put it in because it's an ex-student of mine who decided not to turn up and be a juror, and decided to skip his jury duty. Well, have a look at that article and see what happens as a result of that. So there you go. Right, that's the use of lay people in the court system. So let's move on and look in more detail at the judiciary, particularly Crown Court judges. So judiciary is all of the judges in the country's courts. We've got 3,000 court judges roughly in this country, and they have 6 key principles of being a judge. Now, I don't think you're going to get asked this in exam questions. It's just worth knowing that this is what judges are meant to be. So they're supposed to be independent from government interference. They're supposed to be impartial, not showing one side or another. They've got to have integrity, in other words, be honest and have strong moral principles. They've got to uphold, they've got to show propriety, in other words, uphold society's standards, norms, etc. They've got to ensure equal treatment to everyone who comes before the courts, and they've got to be competent. They've got to know and be able to do the job. Now, I would point out the importance of these two, particularly this one, free from government interference. In our country, the government cannot sway judges. Judges are not elected, they are appointed. Impartial, they mustn't show favour to one side or another. If you go to America, where judges are elected, and in fact Donald Trump has appointed his own candidates as judges of the Supreme Court, that enables the government and the president, particularly Donald Trump, to influence the laws that are passed, so he can get his own way. Unlikely to happen in this country because we don't have that system where judges are elected and judges are separate from the government. In America, it goes another way. I'll be political here and say it's not a good thing. You really have to look at what's happening over there. But I digress. Let's move on. When it comes to funding, the pay, they're paid, because they're public servants, they're paid out of taxpayers' money. The judicial pay is decided by an independent body which recommends the Prime Minister and the Lord Chancellor on how much judges should be paid, along with other people such as MPs, teachers, doctors, nurses, etc., etc. So in 2025, the most senior judge, who is the Lady Chief Justice, has a salary of about £312,000 a year, while as the lowest rank of judges earn £134,000 a year. So if you are a judge, you are highly paid without a shadow of a doubt, more than a secondary school head teacher. But there are only the odd few thousand of them in the country. Now, that seems a lot, doesn't it? But, and it should be a lot, because these people are deciding our laws, deciding our guilt, deciding sentences, etc. And they are applying the laws that our government has made. And let's not forget that judicial precedent and statutory interpretation is a way by which judges create laws. So it does seem a lot, and the top people should be well paid, because you want the best people in the jobs. However, the reality is that many lawyers earn far more than judges. If you are the top of your tree as a defence lawyer, you can earn a hell of a lot more than being a judge. So actually, the pay can be a disincentive for some people to become judges, because if you're top of the legal tree, you can learn a lot more than the Lady Chief Justice. And to give you an example of this, this is David Sherborne, who's one of the top legal barristers in this country. He works particularly in the fields of media and communication, specialises in privacy, confidentiality, and defamation, as well as matrimonial and sports law. Now, if you look through his list of clients, which is here, Diana, Princess of Wales, Benazir Bhutto, Sharon, Tony Blair, Donna Melania Trump, Chelsea Clinton, so and so and so and so, Amy Winehouse, Paul Weller, all the Beckhams, Paul Gascoigne, Ashley Cole, Don King, Mike Tyson. He did the Mirror Group 1 for Prince Harry, the Duchess of Sussex. He is a top legal barrister. How much does he charge an hour? Most sources seem to think his minimum hourly rate is £800 an hour. So when I say that top defence solicitors can earn a hell of a lot of money more than a judge, there you go. That's probably the top defence solicitor in the country, £800 an hour minimum, which means he's charging a hell of a lot more for a lot of people. Which you can understand why the people, if you look at his client list, they are the people that can pay. Now, also, you might want to then think about a two-tier justice system, because if you're rich, you can afford the best, and if you're poor, you can't. Is that fair in a system that's supposed to be equal? But them's the things, them's the rub. So there we go. So let's move on. Final slide, how this all links to other agencies. So courts will obviously work with the police, who are often appearing as prosecution witnesses in court, and transport high-risk defendants to and from court. Police always go to magistrates' courts for warrants, to arrest, to search, detain beyond 24 hours. Obviously, the CPS are closely linked with the courts, because they prepare and present the prosecution case against offenders in court. They will link with the probation service, who prepare pre-sentencing reports on offenders for judges and magistrates. The probation service supervise offenders that are given a community sentence by the court. Any court that gives out a community sentence, those community sentences are run by the probation service, so they have to deal with that. And they have to supervise any drug testing that courts have ordered. When we move on to the prison service, obviously, if a custodial sentence is given by magistrates or judges, the prison service has to do exactly that. And they have to supervise defendants who've been remanded in custody by the court, awaiting trial. And then finally, the prison service have to facilitate visits from defence lawyers to their clients in prison whilst they're awaiting trial, or whether another investigation is ongoing. Okay, so that's the Courts of the Judiciary. Hope you found that useful. Hopefully I'll see you again as we delve deeper into the criminal justice system in England and Wales. Have a good day.